So, the defense hired an accident recon who, even 6 weeks ago in his deposition, was still saying it's a red light, green light dispute. I was like, he must not have read the discovery where the defendant, 4 years later, admitted to having a red. So what I'm gonna do is talk about attacking the defense demonstratives. So the same things they're doing to us that Ronnie and Lourdes talked about, we can do the same thing to them on the motions in limine. But sometimes I don't even want to do a motion in limine on this because sometimes the animation is just so skewed that I like to use it to polarize the case and then get the jury pissed at the defense. So this is the trial we're in right now. We're waiting for a verdict, hopefully get one Monday. This is what happened. This SUV up here, that's an undercover DA investigator who was just at the county building. This is a case against the County of San Bernardino. And our plaintiff was just coming this way, and you're gonna see a crash occurred. It was a red light, green light dispute. Then boom. So this is the case. Unfortunately, you can't see the color of the light. So we had to rely on that independent witness who actually worked for the county who said he 100% had a red light. The cop did. The cop lied at the scene. And then in his deposition 2 years later lied. It was right before the first trial date where they finally admitted he had the red, but said he couldn't see it because the tinting in his car was too bad. It was just all bullshit. He was just a lying cop. And frankly, I think he just went through the red because he's a cop and didn't see these trucks coming. So we'll see what the jury thinks about it. But, and that's my client walking African-American man in a red shirt. So the defense hired an accident recon, Beau LeBlanc, who even 6 weeks ago in his deposition was still saying it's a red light, green light dispute. And even though, I was like, he must not have read the discovery where the defendant 4 years later admitted to having a red, because he didn't say that in his depo, right? He's like, it's still a red light, green light dispute. This witness has a lot of inaccuracies in his testimony. But then I went into his file before I cross-examined him, and I saw that he actually highlighted like the discovery before his deposition. Like you could like right click and see that he's the one who highlighted it. So we attacked him on that. But anyway, so we created this animation. This is a pretty standard animation. I think that it's called the crash or something like that. They all use, all these accident reconstructionists. And so what they do is obviously they take a lot of information from the video and then map it out and try to determine how fast my client was going, because their comparative defense was that my client was speeding. And so I wanted to attack that in multiple ways. And so this is the animation he created, and you can see the speed at the top and how the crash occurred. So, I'm looking at the animation, I'm thinking, okay, like, first, is it accurate? What can we attack? What's missing? All that. So the first thing you want to look at is, are there any details missing? Because I think you should go through the animation with a fine-tooth comb, right? Because if there's any detail missing, you got to attack them on it, no matter what. Every single detail that's not there. I understand it's substantially similar, but I think there's ways that it becomes misleading if there's enough details that are missing. I think the jury's going to get pissed. So the first thing I wanted to attack was, should Mr. Butler, my client, have seen the other SUV? Meaning that, is the jury going to think that our client should have swerved or moved out of the way? So that's the first issue. And so if you look here in the real video, you'll see there was a truck coming in the number 2 lane. So that was one of the first questions I asked. I was like, well, why didn't you put the truck there, right? Just to attack him, because you can see it there. There's that truck. And because I'm like, that's going to block, my client's view of the SUV. So I asked him that.
In the real video, there's a pickup truck that is in the number 2 lane, correct?
Yes.
Is there a reason why you didn't put that truck in there?
It would have taken analytical time, to track that pickup truck, to accurately represent it. And I didn't endeavor to do that. It didn't seem like it was necessary.
Would that pickup truck have in any way blocked Mr. Butler's view of the defendant's vehicle?
I think it could likely have blocked their lines of sight of one another, both Mr. Butler and Mr. Lozano.
So two things happened there, right? One, he made it become a material issue, a material detail, because it's like, all right, bro, you can't see the truck. They can't see each other. That seems to be a big fact when you're trying to determine, the jury has to assess who's more at fault. So why would he leave it out? And then it begs the question, his initial explanation was that it would have taken time, analytical time. He's like, they paid this dude $50,000. Like, trust me, he would be happy to do that. He would gladly take the county's money to do this analytical time. So the whole thing, when he's saying this, and I played this in my opening statement, it just starts to look fishy. And so you just want to find, and there's a lot more that I'm about to show you that makes it look fishy, but even if this is all I have, jurors just don't like that. They just don't like these kind of responses. So that's why don't ignore any detail. You want to call every single one out, because you'd be surprised it starts to become material, and every little detail that's changed, it looks like they're trying to hide something or mislead. And that was a big theme in our case, is that the county is just misleading every step of the way. And this was just one way they did it. So you can see here that would have blocked. This is what I showed the jury, that basically this is very simple demonstrative right here. I just took a Google map and a white square, but the jury will get the point, right? It's just blocking the view for both ways. You see the crash here. By the way, the county said give him $4,200. I'm not kidding. In closing, they said give him $4,200. It's crazy. I've never had a defense attorney say that low. So either the jury's going to believe him and I'm screwed and you'll see it on the listserv, or hopefully they get pissed at the county. Are there any details wrong? So this is another key, right? And with any kind of animation or demonstrative, you need to run it through your expert too, right? You want to say, hey, is there any, especially accident reconstruction, because he's relying on the speed. So we don't know. So you got to run it to your expert. Are the calculations correct? Is there anything wrong about the demonstrative? And I didn't use an accident recon. I just had one paid to consult with. But one thing he did say is, he said, look, the speed's probably right. He's probably right on the speed. So we can't really attack him on that. But in a different type of case, a different scenario, what he did point out, he said, these lines here are the place of rest, where the vehicle's technically, according to the photos of the crash, came to rest. And he's like, he didn't have it accurate. By the way, the color of the cars were wrong. So I'd call that out too. But he has the white car come to rest here, whereas when he did his measurements, it really was here. So why did he do that? Because he would either have to start at the resting place and then work backwards to have an accurate animation. The reason I didn't bring it up, because my expert was like, you probably don't want to call that out, because then he's just going to say, yeah, that means your client was going even faster, because it would have pushed the car even further. So I didn't want to go down that path. But for you should look at that kind of stuff, because it matters. Because it matters if one calculation's wrong, it's going to mess up the rest of them. Okay? So always look at every little detail with yourself, but then also with your expert, every single detail, to see if anything is incorrect. So the next thing in these, especially accident recon animations, is did they run an alternate scenario? Because I'm sure most of you who try cases, or you've seen that anytime, especially when speed's an issue, they're always going to run the alternate scenario to show the client going at the speed limit, and then the defendant just goes and everyone just moves along living their life just fine, right? That's what they always show. It's like, oh, look, if he was following the law, we wouldn't be here. And he would have gone off and done whatever he was doing. So did they run that? Did they give an alternate scenario and do an animation for that?
So, and let me ask you this. Have you done the calculations to determine if Mr. Butler was traveling at 45 miles per hour, this crash wouldn't have occurred?
No.
Okay. So I'm going to ask you again, are you ready and prepared to offer the opinion here today to a reasonable degree of scientific probability that if Mr. Butler was traveling 45 miles per hour, this crash wouldn't have occurred?
No.
Okay. Are you going to give the opinion that if Mr. Butler was traveling 46 miles per hour, this crash wouldn't have occurred?
No.
And you're not going to offer any opinions as to the fact that Mr. Butler was going above the speed limit was the cause of the collision, correct?
Yeah, I'm not going to offer any opinions that are a cause of a collision.
Well, are you going to offer any opinions that because Mr. Butler was going above the speed limit, that is the reason why the crash occurred?
No, I'm not.
Okay, so anyway, at trial, this is his testimony at trial, and I said what I just told you, accident reconstruction across the country, they do this. They do an alternate animation, what you believe is a fact show, as well as if the party's going the speed limit. He's like, right, we do change 1 or 2 parameters. He's like, it's really easy calculation. So no one told you not to don't do that scenario? No, and you could have done a scenario where you had him traveling 45 miles per hour and done an animation. Yeah, I could have. You have to make some choices about how you lay out the hypothetical, but yes. And then I ask him, but you didn't do that here, did you? To show this jury what would have happened. And then you hit them with this, the CACI 203, the party having the power to produce better evidence. If they didn't, you distrust the weaker evidence. So did the speed even cause the crash? He said, do you have an opinion as to whether the accident would have been avoided had plaintiff been traveling the speed limit? I can't say that to a reasonable degree of engineering certainty. And he says he just can't say that. So you always want to attack the opposite or the alternate scenario because they don't do it and they're lazy. So that's all I have for attacking defense. Any questions?